Welcome to episode 4 of our first season, our inaugural season called Unreasonable Doubt, the Casey Anthony murder trial. I am Joel Oster.
I'm Leandra Hazlett.
And today we are at showtime. In today's episode, we are going to unpack the trial, what took place at trial as they're building a circumstantial case. And so, Leandra, I'm excited to get your opinion on this because this is what you do. I mean, you are a prosecutor, so you prepare cases for trial all the time. So I have a lot of questions for you, but any thoughts out of the gate on the Casey Anthony murder trial as they are preparing for trial? Now, the murder happened in 2008. Trial is going to start in 2011. So you got about 3 years there. What are you doing as a prosecutor to prepare your case generally it's 3 years.
Sure. So that's a long time to prep a case. Ordinarily, things get to trial within a year. So, with how sensationalized this case was, it's not surprising that it took 3 full years. But I don't want to make that seem like the prosecutors weren't working at it every single day. This was a file that, sure, go ahead.
Why is it taking 3 years? I mean, you have a right to a speedy trial. And right now, during this time period, Casey Anthony is sitting in jail. I am thinking of Amanda Knox over there in Perugia, Italy. She's sitting in jail for 3 to 4 years, waiting for case even for trial to start. We have a right to a speedy trial. Why the 3 years? Well, what's going on?
Sure. So anytime the defense continues the case, it tolls speedy. So her right was eventually waived. Her right to speedy was eventually waived, whether that be intentionally, where she signed off voluntarily saying, hey, I'm waiving speedy trial, or she just continued it out past the 6-month mark. It's not unusual for bigger cases like this for people to waive speedy, because there's a lot of stuff that needs done for a thorough and fair preparation when you're proceeding to trial. Lots of discovery tools like depositions, lots of witnesses that need depositions. A deposition is a under oath recording or transcript of a witness's testimony prior to trial. It's beneficial to both parties. It's a discovery tool, so there's no surprises at trial. Both sides know exactly what the witnesses are going to say and what information that they have.
So I know in civil cases how depositions work. How do they work in criminal cases? Can the prosecution just depose any of the fact witnesses in a case?
Usually it's the defense that files motions for depositions in criminal cases because they're the state's witnesses. So the state has already met with their witnesses. They know what information they have, what they're going to testify to. Defense attorneys are going to file the motions for depositions. The court's going to order them, generally speaking, and it's actually the defense's deposition. So the state is in essence defending the deposition. It's very rare or not rare, but unusual for the state to file motions for depositions. I recently just did it. I filed a motion to depose the defense's expert witness, but unless the defense is putting on a case, they have witnesses identified, it's not something that the state generally does.
So
although I do have that ability.
So in a criminal case, will it come a time where there's actually a scheduling order that's issued, and so the defense will know these are the witnesses that the prosecution intends to call, and the prosecutors will know these are the witnesses that the defense intends to call?
Yeah, so in Nebraska, at least where I am, when I file a felony information in the district court, I identify early on. So in that initial filing, my identified witnesses, I'm allowed to amend and add or endorse additional witnesses later on as discovery comes out. If there's other witnesses that are identified in the process, I'm allowed to go back and add witnesses, but there's no secrets. There's never a bombshell like movie moment at trial, generally speaking. Both sides know, they should know exactly what everyone's going to say.
Now, you say that, and I get what you're saying, but I also know that in this case, During opening statements, there was a bombshell that was levied by the defense. So, to a certain extent, the prosecution was caught off guard. They didn't quite know how the defense was going to present their case. And so, we'll have to get there in just a minute. Before we get to the bombshell in the opening statement, I want to talk about voir dire. Now, I assume, and I don't want to be ageist when I ask this question, so please forgive me. I'm not trying to pick on your youth and inexperience. But
That's okay.
have you seen the movie My Cousin Vinny?
I have. It's been
Okay.
a long time ago,
All right.
but I have seen that movie.
You're about the same age as my son. And I asked him recently if he'd ever seen the movie, and he said no. I'm like, what a miserable father I am. How is it that my
And you're
son,
a lawyer.
I'm a lawyer, and it's only the greatest legal movie of all time. And so my son watched My Cousin Vinny, and do you know what his statement was to me? He goes, Dad, why didn't you tell me? I had no idea that Spider-Man's aunt was in My Cousin Vinny.
That's
Okay,
funny.
that's how you maybe refer
I
to her
think
as.
I
Go
think
on.
Liar 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 is arguably one of the best legal movies of all time
It is. Well,
with Jim Carrey. I'm a huge Jim Carrey fan.
you will not get any arguments from me. Liar, Liar, and My Cousin Vinny both can teach their own CLE. You can learn a lot about the practice of law just by watching those two movies. Maybe we should do a podcast just on those two.
Yeah.
Well, My Cousin Vinny actually was, the director was emphatic that every scene be realistic and actually represent things that would actually happen in a real court of law. So yes, you can watch My Cousin Vinny and actually learn about the practice of law. I have no idea where I was going with My Cousin Vinny. Oh, I know, voir dire. You know, in
Sure.
My Cousin Vinny, they're doing voir dire. You're trying to pick your witnesses, and he had a lot of fun trying to say that. In here, we're going to voir dire. Could you just explain to our listeners what is voir dire? And
Sure.
then I want to know, as a prosecutor, in this case, what are you looking for?
Absolutely. So voir dire or voir dire, no one really knows how to say it, and that's fine. We
Okay.
pay a lot of money to be attorneys, and no one knows the proper way to pronounce it. But however you say it, it means to speak the truth.
I
It
did
is
not know
a
that. I did not know
Yeah,
that.
yeah. It means to speak the truth. And so that's what I tell people when I go in, and this process, okay, is jury selection for those who want something easier to say. So there's a veneer or a pool of people who come in who have been won the lottery, if you will. I've always cracked that joke too to break the ice. I'm like, some people win the lottery, you all are here. It's a lottery, kinda. And I'm so thankful that you're all here because, I'm like
You,
nerding out. I'm like, this process is incredible. And I'm like giddy about it. And they're all like cranky to be selected for jury selection.
yes.
Um, so during that process, I tell them, what I just said, it means to speak the truth. I'm not trying to be, I'm not trying to invade your privacy, but I need you to be so honest with me. So honest. I want you to over disclose. And if you're uncomfortable, we'll go talk in chambers with the judge and the defense. But I need to know, like, whatever the answers are. This process is a period of time, the only period of time where the parties get to talk with the potential jurors and then ultimately 12 of them become your jury. So it's super important that you're building rapport, and you are also getting all the answers you
Now,
can
what do you
out
mean
of.
by that? Because that's such a huge issue. I want to make sure our listeners don't miss that, because the lawyers are talking to the jurors during the entire trial. What do you mean this is the only time there's back and forth between the lawyers and the jurors?
Right. So as soon as a jury is actually selected and the jury has been impaneled, the attorneys and defense, the defendant and the parties, and all of the parties involved are no longer allowed to communicate directly with the jury or an individual juror. It is admonished. There's an admonishment given before every break. It's not because we're rude. It ensures a fair process. If we see them out in the hallway, we are not allowed to wave or smile or make and that's really hard for me because I'm a nice person.
Wow.
But
You know,
I do know the rules. So
I,
I like straightforward. Don't look at anybody when you're walking in the hallway.
I know this is a little bit of an aside, but I'm just going to pick on you here a little bit. You would agree with me, would you not? That is sacrosanct. I mean, you can't talk to the jurors, and if the lawyer does talk to the juror outside of that context, the lawyer might be disbarred. I mean, it's that serious of a
It's
rule, right?
serious. It's super serious.
Yeah,
It's grounds for mistrial. It's unethical.
exactly.
All
It's
the things. All the
horrendous.
things.
Yeah.
Yeah, it's bad.
So
Bad. Don't do it.
I'm setting you up. I think you recognize
Yeah.
that. Did you know that
So,
Honest Abe, Abraham Lincoln, are probably number one lawyer that we all esteem to be, regularly had lunch and had conversations and told jokes with lawyers during the entire trial process? If Honest Abe did that, why is it so bad now that we are disbarred for even thinking about looking their way in an elevator?
I don't know.
Isn't that weird?
I don't.
Yeah.
Yeah. Times have changed.
Yeah, I know. Sometimes we get
Uh,
so tunnel vision of this is what the rule says, this is what the rule says. Well, 200 years ago, the most ethical lawyer in the history of law regularly talked to lawyers or jurors during
Jurors. Yeah.
yeah, during the whole process, but whatever. All
I
right,
get
go.
it. It's a protection. Make sure that no side gets any undue influence over the jury. So it's important that you build rapport because you want the jury at this time to get a feel for who you are as an attorney and what you're doing, what your job is. So I lay out the process. I lay out, the foundation of what we're doing, and then I answer or I start asking questions. The questions start off easy, very general questions. What do you do for a living? Are you married? What does your spouse do? Those types of questions. That really doesn't give too much weight on if we select them or not, depending on the situation. Just it can lead to more answers that might be beneficial to one side or the other.
Okay.
But it also makes them feel comfortable and get used to communicating with you. And then we get into the case specific questions, which are different case to case. So in a case like this,
Yes.
I want to know who has children. I want to know who has uh, young children. I want to know who works with children. I want to know who's educated, and by educated, I mean nurses, doctors, lawyers, teachers, people that are out in the workforce, someone who runs a daycare. I want to know, it doesn't matter what the job is. I want to know what they do for a living. And if it involves children, does it involve more of a party? Are they, like a young female who's bar hopping every weekend and serving to put herself through school or whatever? Might not be my first choice here because she might identify with Casey and I'm the state and I'm trying to prosecute Casey.
Okay.
Um, so that's kind of the vibe. I want to know who has served on a jury before. I want to know if it's criminal or civil. I want to know if they found if it was criminal, if there was a conviction, or if they acquitted. I want to know how their experience with the jury process or trial process previously was. Those kinds of things that are not case specific, but are legal process specific.
All right. So generally
Um,
speaking, you get to strike some jurors for any reason under the sun. That's not a prohibited reason.
right.
In Nebraska, for example, how many would that be? Three.
So no, it depends. So this is actually really weird. I learned Nebraska's misdemeanor court, so county court, we only have 6 jurors, maybe one alternate if we think it's going to go 2 days. Whereas in district court, so felonies, it's 12 jurors, maybe one or two alternates if it's going to be a multiple day trial. So, excuse me, with the veneer, and I can't do math, but for easy math in county court, the pool is 12 people and each side gets 3 peremptory challenges for any reason. So we can strike three people and they get
Okay.
to strike 3 people. In district court, I'm trying to think and do the math because the veneer is huge, but I want to say it's 36 people and each side gets 12 peremptory strikes.
All right.
I
Now,
think.
to help you with your math here, you just
Yeah.
basically took care of every single person who's on the panel. Aren't there strikes for cause as compared to strikes for
Yes.
any reason? So how does that play into it?
Yeah, so a strike for cause, they're unlimited, but you have to essentially prove or make a showing that that person cannot be fair and impartial, and you have to move the court to strike so the court actually strikes
I see.
the juror for cause. again, that's a really high burden because when the court inquires after they're like, I think she's guilty, blah, 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 blah. And the court can be like, okay, Miss Jones, you're telling me you can't follow the Constitution. You're telling me that you can't follow instructions, and I'm telling you she's presumed innocent. You're telling me this, and the person has to be pretty strong in their convictions and say, no, I can't, and I think she's guilty, and I am not fair and impartial. Those are the magic words. So,
Right.
absent getting somebody to admit to the court, the man in the or woman in the robe, that they cannot be fair and impartial, you're
Like
not
in
going to get them struck for a cause.
like in this case, let's just say I were on the potential juror, and I've never been a potential juror. I've never once even been called for potential jury duty. I have no idea why that is. I assume it's because I'm a lawyer, and somehow they cross-check these lists, and they don't even call me, or I don't even get the letter.
That's
All
so
right,
funny.
let's say that I get called, and I say, in this kind of case, that I'm really opposed to the death penalty. I could not render a verdict in this case of guilty because I know the death penalty might be on the table. I just can't go there. If I said that, would I get knocked off for
Not
cause?
necessarily.
Okay.
Not necessarily because the judge is going to instruct you. The judge is going to inquire. They're going to be like, "Okay, so your job today or the during the pendency of this trial is to come up with a finding of fact and decide if they're guilty or if Casey Anthony is guilty or not guilty. Your job is not to determine what happens to her. That's my job. Can you follow that instruction? Can you assess the facts and decide whether or not she's guilty or not guilty, innocent? And they would have to say, no, I can't do that, and I'm not fair, and I'm not impartial, whatever. However, that's for cause. If I hear that as the prosecutor, right? Somebody says that during the jury selection, I'm making notes. My co-counsel's making notes, right? And when we go back to strike and use our peremptory strikes, that would be something that I'd be like, all right, we're gonna get that person, boot that
Yeah.
person. That
Right.
might be somebody the defense wants. So they're not
Right.
going to strike them. They're going to make me
Oh
use one.
yeah.
It's strategy. It's like chess.
Uh,
They're going to, and it's funny. I've had this happen where we're like, okay, I think that they're going to strike her second, but they also need to strike this person. And we're playing games back and forth. And I use my last strike and then I send it over knowing that the only one they have two or three people they still need to strike, but they only
Ah,
have one left.
I
So it is
see.
a little bit of a game of
Right.
strategy.
But
Um,
I'm telling you what, if I were in a jury there in Nebraska, you would want to strike me because I am way too defense sympathetic. I'm always, oh,
no,
there's reasonable doubt. I mean, I could conceptually see how maybe this person's not guilty and didn't do it, and so
no,
I'd be a
no
prosecutor's worst nightmare.
way.
All right,
Yeah, no kidding. That surprises me.
I know. I
That's
have no idea
funny.
why that is. Oh,
Especially with, yeah, that's interesting. We should unpack that sometime.
how
I
is it?
want to say one other thing.
Yes.
Um, with the peremptory strike, though, before I use my strikes, before all that happens, while I still have the floor with the jury, before I pass the panel for cause, I would inquire further about the death penalty or whatever that person was saying. And I would open up the conversation to the rest of the pool of people and say, who agrees? So we can identify who agrees with Miss Jones that she
Ah,
can't,
okay.
right? Or who disagrees. I had an incredible shout out. I'm not going to shout them out because I don't want to give my location away.
Right, right,
But
right.
during law school, I had the privilege of learning jury selection or voir dire from an incredible judge here in the area, and he was a career prosecutor before he took the bench and had the most insane strategies with jury selection and like reverse psychology. And he's like, you're the state. So you don't want to identify who's good for you because that, in essence, identifies who's bad for them. You want to pose your questions in a way that you don't give up who supports you. You want to
Ah,
identify only who's good for the defense and be able to strike them,
okay.
which I think in practice, it takes a lot of practice because it's like the inverse of how your brain wants to work, or at least how my brain wants to work. It's a
Right, right.
difficult
I get it. As
thing
compared
to
to
do, but he's
say,
great.
So, in other words, instead of saying who would be my ideal juror, you're going to assume that everyone might be your ideal juror. You just want to strike who is their ideal juror, and then just deal with whatever you have
Exactly.
left. All right, that makes sense. All right, so now let's get into the trial here, because again, I am fascinated by
Yeah.
this trial. I've been fascinated the entire time, and I'm starting to go the entire other direction. You remember when we started this whole segue into the Casey Anthony murder trial? I said I don't see how she is how she's innocent, how she found, how the jury found her not guilty. I don't understand that. She's as guilty as sin. Do you remember I said that?
Yes, yes, I do.
I've now dug into the trial, and I've listened to the evidence, and I've listened to the witnesses' testimony, and now I'm kind of on the other end. I'm kind of now seeing, okay, yeah, this is the one that fell through the cracks. I can see why the defense won this case, and the prosecutors did not score a conviction. And so maybe you're going to stop being my friend. I don't know. Maybe you're going to see me as being some kind of project. You can change
No,
me. I don't
yeah.
know.
No. Here's the thing about this case, and I said this in the very beginning as well. It's not, this is the case that I learned. It's not what you know, it's what you can prove in a court of law. And unfortunately, this case isn't something, it's different day, same, or excuse me, different day, different set of jurors. Maybe we have a different outcome, but that's the way our justice system is set up. And for whatever reason, and that we're going to get to those reasons, it's not what we knew. It's not what we feel. It's not all of these things that add up. It's what we can prove. And unfortunately, we fall short of beyond a reasonable doubt here. And I am with you 100%. I absolutely, well, I don't know 100%. I'll say 90% because I don't know where you differ. I believe she did it, but I understand why they found her not guilty.
Yes, it's starting to make sense here. So let's unpack. What do we know here before we get to trial? What we know is that Casey is not getting any world's greatest mother's mugs, right? I mean, that's not going to be a thing. She's got to forfeit every single Mother's Day. She
Yeah,
went
yeah.
31 days and did not know where her kid was. Theoretically, she's out there partying. I mean, all of her actions during this 31 days is highly suspect for an innocent person. I mean, I don't know why she was doing the things that she was doing. Let's just go over a couple of them. I mean, she was out there partying every single night. She was with people. She's constantly lying to her mother about where Casey was, made up these horrendous lies. Why would
Horrendous lies.
why would you
She's
lie about this? Why?
because you're guilty.
I mean,
Yeah,
that's the assumption,
she
right?
got a tattoo. She was in like a wet t-shirt contest. She's at the bar. She's blacking out. She's living her life. Um,
So
on
as
the
a
run,
prosecutor,
really.
you're thinking right now, score, this is a layup. In basketball terms, this is a gimme. It's a layup, right? These are free points
Yeah,
here.
like,
It's a little
and I'm
bunny.
on my own. Like, no one's there to defend me. This is crazy.
Yeah.
Yeah.
And so is there this thought that prosecutors might be overconfident in this kind of case? That this one is such a slam dunk winner that they might mail it in? I'm not saying they did, but do you think that's a thought that some prosecutors think that this is
I
easy?
well, that would be their first mistake if they thought a case was easy because obviously any trial is a risk, unfortunately. Like this case illustrates, it's possible for juries to do stupid things, to
All
make the
right.
wrong decision.
I agree with you, but then I almost wonder again, I'm almost on the other side where I almost think that maybe she's right. Maybe her version of the story makes sense. Now, I'm going to reserve judgment on that one. Let's dig in here. So that's where that's where the scorecard is here when you start trial. Clearly, she's guilty, and everyone in the public knows that she is guilty. I mean, come on, for crying out loud, she's actually sitting in jail for what, a month? It wouldn't even help people locate her daughter when there was a national search going on. Well, okay, we get all that. Now let's go to day one of trial, opening statements. And this is what the prosecution said. So the lawyer doing the prosecution argument, her name is Prosecutor Linda Drain Burdick. By the way, in this case, you have some male lawyers. Let's see here. Hold on a second. I think this guy who wrote this book, Prosecuting Casey Anthony, it was written by Let's see. What is his
It's
name?
that isn't I'm just gonna use my this moment while you're looking for him. Incredible book, 12 out of 10. Huge fan of that attorney. As soon as you say
Jeff
his name.
Ashton.
Yes.
All right.
Incredible book. Anyway, can't say enough nice things. I hope he sees this someday.
Why would he
Anyway,
not do the opening statement? Why have Linda drain a bird? Is there any thought process that might go into who does the opening statement?
I think when it's a case, if it's my case, excuse me, if it's my case, I want co-counsel, whoever it is, your opening statement is your first opportunity to show the jury what you have. It's a roadmap. You want to hook them in. You want to grab their attention. You want to continue that rapport, right? But you want to tell them exactly what evidence they can expect to see. You want to walk them through the witnesses, what you believe the evidence is going to show, i.e., their testimony. You're going to talk about your physical evidence and anything else you want the jury to know up front. You don't want to oversell your case. You don't want to make promises you can't deliver on because that goes to your trust and credibility.
Yes.
But you want to do it in a way that's elegant enough that they buy into what you're saying, because that's again your first real experience, or your first interaction, excuse me, as an attorney with the jury, because previously you're just yourself. You're walking in, you introduce yourself. This is voir dire, this is jury selection. Tell the truth. I'm myself. We get to communicate like normal human beings, and then it's showtime, right?
Right.
And it really is. It's a performance. It's very theatrical. Trials are very, very performative. My entire job is very performative, but trials especially. So it's really important that you have that strong opening delivery. I don't know that there was any strategy. I'm sure both of the attorneys that were involved in this case, or all the attorneys that were involved in this case, were spectacular at their jobs.
But would
I
the
think they did.
thought, do you think there would have been a thought by the prosecution that this is about a total failure of a mother to be a mother? The most basic rudimentary things that mothers should do with their kids, this lady failed at. And that message was better delivered by a mother as compared to a middle aged guy?
I mean, that certainly could be. It could be far less thought out than that. I can't speak to what they thought. I mean, that's certainly a great thought to have. But at the end of the day, as long as she delivered what she needed to deliver, I don't know that it would have. It really, really, it really matters who gives the opening.
Okay, so you're saying the most important thing here is who can relate to the jury and communicate a message that the jury will receive. And you're right, there are some
Yes, but
key
I do
methods.
think that you're right. And I think you're right. I think if they had that thought, then 10 out of 10 for them for letting the female deliver the opening. I think it's also important, if they are trading off and whoever does opening is the other person does closing, that you have a really strong closing attorney doing closing, because that's your time to argue and sell your case.
Okay. Well, to what you said earlier, let me go come up back with another Abraham Lincolnism. Abraham Lincoln once said that you should plead not what you need not, lest you oblige yourself to prove what you cannot. And so that kind of goes to your point of don't overpromise, because if you overpromise at the beginning, now you're obliging yourself to prove that, and if you can't prove it, it looks
They're not
worse.
gonna, yeah, well, yeah, and you become not very credible, and no, they're not gonna trust you.
So let me give you some highlights from the opening statement from the prosecution. The prosecution said that Casey Anthony, Kaylee's mother, appeared to all outward observers to be what her parents thought she was, a loving mother working hard to provide support for her daughter. But as the evidence in this case and the investigation and the background of Casey Anthony will show, that was an illusion. And then they went over the 31-day period of time when there's a lot of partying, a lot of wet t-shirt contests. I mean, she was the antithesis of a mother, all while knowing or not knowing, allegedly, where her daughter was. Now, I think it's important to note that at this point in the opening, in the trial, they have no idea what the defense is going to be. I mean, how does that play into how the prosecution presents its opening statement?
Sure. So that I think that's a little bit about what we talked about earlier as far as the evidence. There's no bombshell. What is a bombshell? What can certainly be a bombshell at trial is case theory. No one's going to know. No one's going to share that because it's strategy. So ahead of time, when we're, you can, especially the more experienced you are as a prosecutor or as a criminal attorney in general, you can make fair and reasonable assumptions or guesses and try to like get one step ahead and be like, okay, these are the weak parts of my case. This is what I think they're going to hang their hat on. So in a case like this, the defense knew that they were going to paint a picture of a momster, if you will, of Casey, and show that she was doing all of these things and not mom of the year. They knew that, like that's the obvious theme here, right? The state, however, I think it would be real if it was me and I know all my evidence, I would be concerned about the Saudi defense. And that's fancy word for some other dude did it.
Okay.
SOD. Shout out Monty, my favorite professor of all time. The Saudi defense, some other dude did it. So as a prosecutor, I need to be worried about identity, who the defense is going to point the finger at, if you will, because it's not going to be their client.
All right. So this,
Um,
oh, go on.
no, sorry. I there's other reasonable defenses and case themes, but what we're about to share would not have been on my radar because it's not information anybody had except the defense prior to the opening statement. So go ahead.
So this is the bombshell. Jose Baez, the lawyer for Casey Anthony, then takes the lectern, if you will, and presents the defense's theory of the case, which was that here's what happened. The babe Kaylee died during a swimming pool accident on June 16th, 2008, and then George Anthony, Casey's father, discovered the body and with Casey's involvement covered it up to avoid charges of neglect, and they disposed of the remains to make it look like a murder. Wow. I mean, were the prosecutors like just sitting back going like in
What the
disbelief? Are they
heck?
taking notes? I mean, how are they even processing this in real time?
I don't know if they what info obviously I don't know these people. So I don't know the information they had coming into this. Based off the information that I knew or know about the case, I don't know that I would have ever thought the swimming pool would have been an issue. However, earlier I was talking about the obvious defense being some other dude did it. That plays a role here. But additionally, I'm going to, as a prosecutor, I'm going to be concerned about cause of death, being we don't know exactly, how or Kaylee died,
All
right?
right. So
And her body was too far in decomp to tell.
so the defense oftentimes they are going to craft their theory of the case based upon all the evidence that they think is going to be admissible, right? They're trying to poke holes in the prosecution's theory. And so they looked at all the evidence. They probably said, okay, this theory makes sense. This is our reasonable doubt, if you will. It seems to be supported by the evidence. Let's run with this theory to see if it can convince some jurors that there's reasonable doubt in this case. Now, what about this next argument? This one also, I think, was a shocker. The lawyer argued that Casey's erratic behavior and her lies stemmed from years of sexual abuse by her father and brother Lee Anthony. Now, again, that's as a
That's the
bombshell.
bombshell.
That's the
That's
bombshell.
the bombshell.
So,
I, as a prosecutor, expect the defense with not of the pool. I wouldn't have thought of that unless I had information for that. But like giving an alternate theory of death, so it's not intentional, totally can buy into that. The sex abuse claim, what? Like that's crazy.
now, again, I'm going back to Abraham Lincoln. Plead not what you need not, lest you oblige yourself to prove what you cannot. I'm thinking that the defense is worried about, okay, our first theory here, which is the swimming pool accident, kind of makes sense, but yet it's inconsistent with what the dad did, right afterwards. And the dad seems to be an upstanding person. And it's also inconsistent with how the mother acted because it's not, she's out partying. So that's not jiving with
And
how
by
people are.
dad, you mean grandpa, right?
Grandpa, yes, yeah, I mean her
Grandpa. Okay,
dad,
yeah.
the
No, no, you're
grandpa,
good.
yeah, yeah, yeah.
Right.
And so they add this element to the story, and all of a sudden now, as a juror, I'm thinking, well, okay, this could make sense. I mean, if there was sex abuse going on in this household, that would explain why she acted so erratically. And now I can't trust anything that comes out of the grandpa's or the brother's mouth, or
Right.
the Casey's brother's mouth. So, what are the problems though, or the dangers for the defense here in coming out with this theory? Because this is a, are they now going to have to prove it's sex abuse, or is it just enough that they've alleged it?
Not at all. Absolutely. So, the fun fact of the day is the defense gets to show up on the day of trial and not open their mouths at all. Like they have no duty to present a case. The burden rests with the state and it never shifts. It never shifts. Beyond a reasonable doubt is the state's burden. So at the end of the state's case, the defense doesn't have to call a single witness. They can just say the state didn't prove their case beyond a reasonable doubt. And so like here, they get their spin on it. They get their day in court. This is their case theory. This is what the evidence we believe is going to show and how it's going to fall short, right? And this is why it's going to fall short. So they don't have to prove a damn thing. That's another Monty quote. They don't
But
have to
it,
prove a damn thing.
but if I'm on the jury and I'm thinking, okay, you've alleged this second point here, but what if you don't prove it and you offered up no evidence? I'm suspect. I'm thinking, okay, that now you've kind of gone too far. You've alleged these guys to be monsters, and if I don't see that in them, I'm gonna discount your. Is this like a Hail Mary pass by the defense? I mean,
I think this whole case by the defense is a Hail Mary, and this isn't the first this is not the first Hail Mary Jose Baez has thrown and been successful on. He was also Aaron Hernandez's appeal attorney on one of his murder convictions. So the Hail Marys are no
okay.
stranger to Jose Baez. But yeah, I would argue his entire defense is a Hail Mary, and it was crazy enough to work.
All right.
I still don't think we're gonna get to it. I still don't think though that it's that the jury bought Casey's story or theme. I don't know that they bought into to it, but they did buy in to the reasonable doubt and
Well, but hold
found that
on.
the state didn't meet their burden.
I see what you're saying, but I almost think that's not how the juror's mind works. When you present this crazy of an alternate theory, is it not one or the other? I mean, and now it's no longer can the prosecution prove their case beyond a reasonable doubt. It's like, which of these stories do I believe? Because if I don't buy this story, then I think they're crazy. I mean, now I'm thinking you guys are so desperate. Clearly, that's indicative that the prosecution is onto something here. I don't know.
Yeah, but that's not the standard. That's not the burden. The burden is beyond a reasonable doubt. And I think when we go through the evidence that was presented, we talk about it more and tie the forensics back in, we're going to identify that's doubt. If you're hesitating, that's doubt. If there's an alternate theory that you think is plausible, that's doubt.
All right, so let's dig in here. The first witness was George, the grandfather. Kaylee's grandfather. He takes a stand. He denies that he ever molested his daughter or knew anything about Kaylee's drowning. And so he was the first witness to take the stand. Any thoughts on George being called right out of the chute by the prosecution?
I think that calling witnesses is another strategic move, the order you call your witnesses. I think you start at in the genesis, the very beginning. So if that be the victim who is deceased in this case, so obviously we can't call her. Um, we're gonna call in order chronologically if it makes sense. And I think calling dad first gets ahead of the defense's theory. We get him out in the beginning, we own it, we say this, we introduce George to the jury, we talk about all the things, we get it out in the open because we're not here to hide anything. We're the state, we're not hiding anything from you. And let him um, get his testimony out. and out of the way.
Now, but would you not agree with me that most likely George was their first witness, was going to be the prosecution's first witness before that day even started? I mean, they had in their notebook, George is witness number one.
It is likely, yes. I don't know
Yes.
that there was any strategy between calling George or Cindy first. I think
So they
I
get up
think
there and they hear the defense say George did it. He's a sex abuser and he's a complicit in this cover up of the murder. Does that? I mean, do you think the prosecution maybe we should shuffle this around, or do they still think yeah he should be our lead witness?
I think if I don't know. I can't speak to what they were thinking, but I think that if it were me and I was calling Cindy first and then I had the bombshell of George, I'd be on top of that as fast as I could.
So
If in opening the defense says, "Oh yeah, and by the way, he's been sexually abusing me my whole life and I don't know, might be Kaylee's dad or Kaylee's dad is in dispute and like this is their theory, I'm calling George first."
all right, a couple of interesting things about George's testimony that I found interesting was that he attempted to commit suicide in January of 2009. He was in a hotel in Daytona Beach, Florida. On the night of his suicide attempt, he took several different kinds of medications, drank a case of beer, and he left a suicide note to his wife, Cindy. And in this suicide note, he said such things as, why is she gone? Who put the body there? These were things in the suicide note that indicated he had no idea who put the baby there, who put the body there, and how this happened. If you're leaving a suicide note and you attempt a suicide, that kind of lends some credibility to those statements that he had no idea how this happened. So how could he be complicit? Are you tracking with what I'm saying here?
Yeah, I don't want to read too much into the suicide note because suicide note, like that can be, I mean, it would be something I believe we would have to file a motion on ahead of time to bring it in to argue that's a consciousness of guilt. Like if defense wanted to make that argument, they
But
would have to file that
what
motion
about the
before
opposite?
trial.
The
That
opposite
it,
of consciousness of guilt. So it shows he's not guilty.
I don't know. I don't know.
So the defense did file a motion to keep it out, and the court agreed and kept out of that suicide note, and so they were not able to hear that basically the what the dad said in that suicide note.
Yeah. I can see it both ways.
Interesting. All right. So then that was George. And the next on day two, the next witness was well, several different witnesses were called. Several house witnesses, like Casey's boyfriend, roommates, testified as to what she was doing during those 31 days, i.e., party girl, i.e., shot girl, going to the Fusion nightclub, doing a bunch of partying and things like that.
Getting the tattoo. That's like my favorite thing to like to bring up. Got the tattoo. I have tattoos. I'm a supporter of tattoos. I mean,
What?
like,
You have tattoos?
what?
I thought
I
you were an
do.
intelligent, well thought out, measured
Okay,
individual. And
old
now I
man.
find out.
I'm tatted. I've got hand tattoos.
Oh my
No,
goodness.
I have some I have one on my ankle, my hand, and my rib cage.
All right.
So I'm not like what? Go ahead. You have
Truth
a
be,
tattoo, don't you?
oh, no.
Oh, good.
Truth be told, I'm a wimp. I once wanted to
Oh,
actually get my ears pierced way back when, and that was a popular thing for guys back in when I was in high school and college.
yeah.
And I could not put a needle in my ear. There's no way. And so I am.
That's funny.
There's no way to put a
I'm
needle.
also super pierced. My parents were pissed. I came home with a nose ring when I was 18, and she's a part of me now. I can't take her out. So my mom's like, "You'll never have a job," and I'm like, "I'm a lawyer," and I try cases, and I have a nose piercing in my face.
No.
Anyway, so my favorite thing to bring up is this tattoo because the Bella Vita or whatever. It's like it's a beautiful life. Like, girl, your daughter's missing. What do you mean? She's dead. What do you mean? It's a beautiful life. You're crazy.
And
You're
even
crazy.
knowing the defense's theory that she knew her daughter was dead and they just left her out there to, she's still doing that and still partying during that. Does
Yeah.
that make sense to you?
No, no,
Yeah.
that is not a mourning mother.
All right. So Brian Berner was also called, and he was the neighbor for the grandparents, and he testified that on June 18th, so we're talking 2 days after June 16th, when
Remember
what?
the timeline. Remember
Yes.
the timeline.
The Casey went over there to ask to borrow a shovel, and then returned the shovel about an hour later, and she said it was to dig up a bamboo root. Any thoughts on day one or day two of trial, calling these witnesses to prove that she's a party girl, and then bringing in Brian Burner?
I think you kind of cut out. What did you ask me? Any opinion on what?
The calling the witnesses to establish her as a party girl, is that a good call, good strategy by the prosecution? And then having Brian Burner testify about the
So
shovel.
interesting that I want to know. I would have to look to know their extensive testimony on the party girl. Like, was the party girl um, evidence alluded to, or was it factual? Like, oh yeah, we were out at this bar on June 1st or whatever. What in the timeline? We went out to this bar and we did X, Y, and Z. Blah
Yes.
blah 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 blah. Rather than it being character evidence. Okay, because I was gonna say the state can't introduce character evidence. Like, we're not allowed to bring up, oh, she's X, Y, and Z, right?
Right.
We can only do that if the defense offers first. We can then it opens the door, if you will, and then
Interesting.
the state can put on their own character
So
evidence via testimony or whatever.
they could not present these people to say she's a party girl per se, though that is the implication. They're using it to
Right.
say, factually.
This is what we were doing in the timeline, right? And this is
Right.
my firsthand knowledge of all of these things that we were doing together during these times. So yeah, they're wafting the innuendo.
Okay. Then they called Simon Birch to the stand, and Simon Birch was the manager of the towing company that impounded Casey's car in June of 2008, and he testified about the horrendous smells coming from the car. Apparently, he had impounded 6 to 8 cars with dead bodies. I don't even want to know why that's a thing for
Right.
impound lots. Oh yeah, regularly
In
we
the
check the
Florida
dead
heat,
bodies.
yeah.
Really?
Ugh. Yeah.
And so he apparently he was used to the smell. I find that interesting. Does that qualify him
And
as an expert in this to be able to testify to that?
sure, so experts have to be qualified by the court. I don't know that he was qualified in this case, but anybody can be qualified as an expert if they have sufficient knowledge. In fact, isn't it My Cousin Vinny where she's testifying about the tires
Yes.
and she's qualified as an expert?
Yes, in general automotive knowledge.
Yeah,
And
yeah.
they qualified her and she met it.
Yes. Okay, sorry, sidebar. But yeah, so I don't know that he was qualified as an expert in this case, but he was, based off of his own firsthand experience, allowed to testify to his experience as a tow truck driver, his experience with dead bodies, the smell of dead bodies, and then his firsthand experience of towing and smelling the car.
Well,
Casey
let's
Anthony's
say
car.
he had never smelled a dead body. Let's say it was me, for example, and you call me up as a witness, and I want to say, yeah, it stunk to high heaven. I mean, I guess I could say that. I couldn't say it smelled like a
Yeah,
dead body because I have no idea, no point of
right.
reference. So at a certain point, you got to build the foundation of why my testimony is relevant.
Right. And it would get objected to on foundation. I would have to show that you have some type of experience to know what decomp smells like. Um, yeah, this case, and I would point out that the way they're calling the witnesses are chronological. We're building the timeline, the partying, the shovel fits in. Okay, now we're to the point where the car gets towed. Okay, there's a dead body in the damn car. It smells like now that's person number 2 saying it smells like there's been a dead body in the car. This person of which has had experience with dead bodies. So
All right.
that's
Mallory
interesting.
Parker then gets called next. Now, she is going to be a surprise witness against the prosecution. So again, this is the prosecution's case. They're calling Mallory Parker, who was the fiance of Casey's brother. I believe his name was Lee. And so the prosecution is calling her. So you're thinking she's going to somehow be friendly to the prosecution's case. But what she testified was that she'd observed the very special bond between Kaylee and her mother. And she was crying while she was testifying. Casey was crying while this testimony was going on. And she said that Casey and Kaylee had a really special bond. And the question was asked by the lawyer, did it appear genuine to you? And the answer was yes, it did. And so I said, and the question was, in the best way that you would describe their relationship would be amazing. And she said it was amazing. And so I don't think the prosecution was expecting this, or else they would not have called her, because now Mallory Parker, the prosecution's witness, is saying that Casey loved Kaylee, and there was the typical great relationship that you would expect between mother and daughter. How do you think this hurt the prosecution's case?
I think it would be, I don't know, I almost think that it builds credibility because no one's accusing Casey of not loving her daughter. I even said it, I think, in a previous episode where I'm like, whoever did this to her loved her. They put a heart sticker on her duct tape. But just because you love somebody doesn't mean you can't accidentally or intentionally kill them in a rage, in a moment of whatever you want to call it. Obviously, I don't think I would be super pleased if she was my witness and I didn't know she was going to testify to that. You're saying you're saying that the state called her?
Yes, this is the state's witness.
That surprises me. I want to know if she was deposed ahead of time because if she said something differently under oath previously,
Right, right,
if
right.
she had been, and it's just that's surprising.
So let
But I think it builds credibility to the witness, though.
I th-
Hey, and go ahead.
I'm thinking the prosecution's case is falling apart right about here,
Really?
because even as you are describing it to me, in my mind I'm thinking, well, there's reasonable doubt. No mother would do this. I mean, the prosecution's theory, I think they went too far. They're saying, look, she's a party girl. She did this to help her party lifestyle. No, I
It's
mean the
conflicting.
the
I see what you're
rage.
saying.
I like when you just said rage. That would have made more sense. Like it was an accident, and then she just
Yeah.
went off the top because maybe she wanted to go out one night and her daughter was not cooperative, and so something happened. Yeah, that I could buy, but some kind of deliberate attempt. I want to go party, so I'm going to off my kid.
Yeah. I definitely think in hindsight, which is always 2020, that they maybe could have done better if they tried her on like a child abuse resulting in death or an
Yes.
accidental type where the mens rea requirement is not intentionally, rather negligently or recklessly, whatever.
Wow. I think we maybe just stumbled on what this whole this whole story is about. This whole story might be about the dangers and perils of over prosecution. They probably went for too
No such
much.
thing. No such thing. I'm kidding. I'm joking. I'm kidding.
Exactly. You got to state your position. All right. Let's go over some other witnesses here. You had some more witness friends and family that were called to testify, and then they get to Cindy Anthony, the mother. Now this is Cindy,
Grandmother.
the grandmother. Yes, this is grandmother's testimony one. I believe she was called three times at least, which I found interesting. But
That is
she,
interesting.
yeah, she obviously is a key witness here because she was the one who started this whole process. She's the one who got on the phone with 911 and told her daughter, Casey, you got to call, you got to talk to them, you got to explain where your daughter is, and this started the recounting of the lies. And so this is where it came out that she lied about Zanny the nanny. I would think this is really into the prosecution's sweet spot because whenever you show you run these tapes, which I listened to those tapes and I thought she's as guilty as sin. Who would be that calm? She's obviously lying here. Any
Yeah.
thoughts about the testimony from the mother and about the Zanny the nanny non person?
Just as a prosecutor, like you said, that is a sweet spot for me. That is exactly the information that I need to come in because in closing, I'm going to identify that I'm going to hang my hat there and I'm going to be like, this is not normal behavior. This is, again, She's partying. She's so calm. She doesn't know Zanny the nanny. All of a sudden, the phone lines are all disconnected. Any contact that Casey had for this woman is just suddenly non-existent. And I'm going to point to this as guilt. Any of that behavior is guilty behavior. And so, yeah.
Would there be any thought in your mind as to calling her the mother either first or last? In other words, you would like to start off with a bang. I know you want to set your case up well, but then you also want to end it well and on a high note. And I would think that the mother would have been really a solid witness to end your case. Or might you be fearing that it is the mother and the mothers do love their daughters, and so there's a lot of danger in calling her at the end?
I would call her certainly first. Chronologically, it makes sense in this case. It's also how I'm going to lay the foundation to get the 911 calls in. I guess I could do that with a dispatcher, but that doesn't feel as, again, we're performing. It's showtime. We're in a trial. We're performing for the jury. And I say performing, and I don't mean that like in a fake way. I mean it like we get one bite at the apple. We've got to
Yes.
give it our all. What is the jury going to hold on to? It's going to mean a lot more if Cindy Anthony's on the stand listening to her jail calls, being emotional as she was, saying, "Yes, I made that call. That's me on the thing. I reported X, Y, and Z," and then they hear it in real time, the recording of the hysterical grandmother who is reporting her grandbaby missing, and then the juxtaposition of the daughter who last saw her, Cindy's daughter, Casey, being like, yeah, she's been gone for like 31 days. And I didn't call it in because I was just looking for her by myself. Like it doesn't make sense.
No.
And so I think that that is something I want out in the very beginning. And then if I need to recall her to tie anything up at the end, that's totally fine. But I would never not call her towards the beginning to set up my case the way that the prosecutor did in this case.
I mean, I am getting more and more convinced this is the result of over prosecution. They went for too much. I know at last episode, I even alluded
No.
to it. It's like, why are they even going for the death penalty? This is not a death penalty case. Knowing that you're going to get a jury that says you didn't even prove your case at all, let alone now you're going for
Yeah.
death. I'm thinking they went for too much here. And so the jury's just saying, you've lost us. As compared to if they just would have went for child manslaughter. This was unintentional, but your daughter died in your hands and at your
I,
behest.
I am honestly surprised, and maybe I don't know this for sure, so maybe this is something that happened and they acquitted her completely. But I am surprised that the prosecutor strategically didn't include lesser charges. Like if you don't find her guilty of first degree murder, then we're asking that you find her of the lesser charge of manslaughter or the lesser charge of child abuse that resulted in death.
Right.
But again, that's it just I would need to know if they did that. But that's something strategically in hindsight they should have done if they didn't.
All right, let's go to the next list of witnesses here, which I know is going to be in your sweet spot, and we are going to come up with a surprise, another bombshell, if you will. But Arpad Vass, who was the forensic expert from Oak Ridge National Laboratory, and he explained the shockingly high amount of chloroform that was found in the trunk. So, talk a little bit about how you use experts in these cases, particularly here when you have a science which isn't necessarily fully developed. In fact, this was the first time that this kind of science was presented in a courtroom in America.
Was it the chloroform, presence of chloroform, or the odor science, or
We're
both?
talking about the odor of what they smelled in the car.
Okay, so in this case, and I might be going off script here. You might have to correct me if I'm mixing up my witnesses, but the trunk of the vehicle, a carpet was cut out, a square carpet where the odor was coming from,
Right.
and forensic analysts did testing on it to collect the odor, which again wasn't a well appreciated or developed science at the time. And I, again, don't know if it even is today, all these years later. But the results were that they were there were very high levels of chloroform and odors in the car, consistent with the odors and chemicals or like compounds
Right.
that come from the breakdown or decomp of a human body.
And let's think about it here just really quickly, because if you smell something, I mean, that's in your nostrils. I mean, you don't really prove that. You don't. How do you prove in a court of law? Yeah, I smelled that. I mean, unless you happen to be an
Right.
expert right there, like maybe that manager of the impound lot was an expert. He could smell human decomposition. But that's only going to go so far with a jury. You want actual
Right.
numbers. You want to say this scored 90 out of 100 or something like that.
You want a lab result.
Yes.
Absolutely. You want somebody that can come in and say, I'm an expert because I have 17 degrees and I'm a doctor of something rather. And I've been
Yes.
working in a lab for the last 20 years and I write research and I'm well respected, do peer reviews and all the things. And you want somebody to come in and lay the foundation that they are that guy and they're going to whatever they say is accurate
So this
and trustworthy.
So this expert Voss, and I hope I'm pronouncing his name correctly, he had as you said, a novel technique. It was groundbreaking for detecting human decomposition from air samples, and then as they would fall and be collected in the carpet, right? Because obviously air samples, how are you going to grab those? Well, you're going to assume the air, whatever the molecules in the air, are going to fall
Are
and
absorbed into the carpet.
yes, then you're
Yeah.
going to test what's in that carpet. And according to reports, that this was the first time these tests had ever been admitted in a trial in the United States. And so, I don't know. Do you think that's going to, are there some issues there in getting a jury to buy into a novel theory like this?
Yes. So and I think that's what happened here. I think that's excellent evidence for the state. Like we can point to the data, we can point to the lab results, we can point to this guy's expertise. The downfall to that is we've now exposed this guy to cross examination. And
Yes.
Jose Baez is no goofball. He's no uh what's it called? He's no bump on a log.
Right, right.
He
Country
has
bumpkin?
he's gonna yeah, no, this guy is experienced and he's gonna cross-examine the hell out of this guy. He's gonna talk about the science. He's gonna point out that this has never been done before. Why would we trust you? This isn't a thing. Is this peer reviewed? I don't think so. And if it is, it's you should we should really ask those peers what they're reviewing because this is crazy. This is new. This is something we can't trust. We can't hang our hat on the beyond a reasonable doubt standard on this bullshit. That's what Jose's job is. And I think that that's something that the jury did consider when considering this case. Sure, this Joe Blow says he's an expert and he's got all these degrees and he's got this stuff he can point to, but can we trust that?
Yeah, and here the main point again, this whole case, this whole trial is about what does a jury of your peers, what will they say about the end result here? And so you got to communicate. You got your points have to land with these individual jurors who are not going to be experts in these various areas. And so now
Right.
the defense comes and they have a witness up there, an FBI scientist, and they got this FBI scientist to admit that the amount of chloroform, the levels of chloroform in the trunk were equivalent to the amount found in household cleaners. And that I think did resonate with the jurors. Like, oh, I recognize that. So that's the same amount that's found in a household cleaner. Well, then maybe someone just tried to clean the back of the car, and that's where you got those levels of chloroform. So it inserted confusion, an alternate theory to the jurors that was easily understood.
I totally agree with that statement. Chloroform, like we talked about, it can be present for a couple of reasons. And we know somebody on the family computer Googled chloroform or searched for chloroform. Um, so it could be present because it was used in the commission of the homicide, or it could be present because of the decomp that was present in the vehicle.
Well,
Either way, the alternate theory being, okay, well, there was garbage in the trunk, and Casey said, "Ooh, this is stinky, and I'm gonna clean it." Okay, well, then we have this alternate explanation. That's reasonable doubt. If you think for a second it is possible, I would not bet my money on one theory over the other. I don't know what to pick. That means you're not putting your money on the state's theory. That's reasonable doubt.
all right. That is the danger of calling in someone to present a novel theory. You would think it would be subject to some rigorous cross examination because it's novel. All right. Well,
Yeah.
thank you for teeing up my next witness. You can't see my notes here, but thank you so much. John Bradley was then called next. He was the software designer who's going to testify about the computer searches for chloroform. Now, this was his testimony. This is where I'm going to come up with a whopper, a bombshell of a disclosure that I am not sure the jurors knew about. In fact, I'm pretty sure they did not know about. But here's what I'm talking about. John Bradley testified that chloroform was searched 84 times on the computer there at the Anthony household. And so they looked up terms such as head injuries, ruptured spleen, chest trauma, and internal bleeding. And this was done in March of 2008 during the regular work hours of George and Cindy. All right, I'm going to drop that into your lap here. What do you make of this? 84 times someone in that household searched chloroform at least 2 to 3 months before the actual murder.
Again, this is circumstantial, but it's huge. 84 times. This isn't someone that's looking up, the effects of chloroform and household cleaner or is chloroform dangerous. This is someone who has taken 84 opportunities to search the word chloroform.
And this is
That
2
is
to 3 months before.
Yep, in the timeline of things, this is wild. Additionally, the note where the 84 times that this took place was during a time that Cindy Anthony and George Anthony were at work or in normal hours that they would not be with access to the computer, which leaves Casey,
Now,
in my opinion.
now,
I mean, who else?
now I got a couple bombshells here for you. Bombshell number
Yep.
one. Cindy then gets called back up to the stand. Will be her third time. And she is going to
Yep.
tell the juror that she is the one who did that search.
Which is insane. When she was recalled, did the state call her the third time or did Jose call her?
I believe, I do not know that. I don't know.
Okay.
I would
I was gonna
guess
say
it's the
that's
state,
really
but I don't know why then she would come back with that. So that might be the defense at that point in time. I'll look into that.
Yeah, no, I'm curious now too.
All right.
I knew that Cindy had taken credit for it, but again, not being able to identify exactly who searched is another point of, in my opinion, reasonable doubt. That's something else the jury is going to say, okay, well, it's possible, but possible isn't the burden. The burden is beyond a reasonable doubt.
Now, here is bombshell number two. You ready for that? I don't even know what to make of this one. I really don't. I researched it today.
I'm nervous at this point.
It wasn't 84. It was once. And that was never presented to the jury. But this John Bradley later on realized, oops, I made a mistake. Told the prosecution he made a mistake, and it was just once. The prosecution sat on that.
Wait, whoa.
What do you make of that?
Hang on a second. You're saying that the prosecutors in this case told the jury it was 84 times?
Yes.
And never told the jury that he made his mistake.
And according to
this
John
is news
Bradley,
to me.
He told
Can you tell
them,
how?
Yeah. I mean,
oh no.
First of all, the jury didn't know that. John Bradley came out afterwards and said, "Hey, look, I told them that there was a mistake in my algorithms, or however I was doing my search, and it wasn't 84. Oops, it was only once."
I thought that is news to me. I thought it was 84 times. You're saying that he testified though that it was 84 times,
yes.
Or his testimony was that it was 84?
Once? No, he testified as 84. And then he realized, oops, I made a mistake in how I analyzed it, the program that I ran, and turns out it was just one search.
That's not good.
And the prosecutor said, yeah, but the defense kind of knew that anyways. And so they kind of just, passed the buck saying.
That's making me sweat. I think prosecutors have to tell the truth.
Yes. All right. More on that as we finish up the case a little bit later on, but I found that was a huge bombshell. All right. Let's move on here to some other. Well, anything then about the forensic testimony so far?
I think just so far that it wasn't a well-developed science. And so while I think it definitely shows, I mean, if you choose to believe it, it shows that there was a dead body in the car, but on the alternative, it's new. It's not super trusted. It's not out there. So are we gonna hold Casey to that level of beyond a reasonable doubt when we don't even know if we can trust this science and base our decision off of that? I don't know.
All right, now let's focus in on the cause of death, because at a certain point, I think the prosecution needs to prove how the death actually happened. The defense has suggested it was an accident. It was a swimming accident. The prosecution
Right.
is going to say no, it was death via duct tape. And so Michael Warren was called, and he testified. He showed animations of duct tape on Kaylee's skull, and Elizabeth Fontaine noted a heart-shaped sticker on a duct tape. Sebastian Shaw identified Kaylee's hair with post-mortem banding. Any thoughts on the prosecution's efforts to prove how the death actually occurred?
I think it's interesting. There was dueling expert testimony as it relates to the duct tape over the mouth. So there was testimony going off memory here that the duct tape was over her mouth and her nose. And we know that because when her skull was found or when her body was found, it was so past the point of decomp, the only thing left was bones and hair. Was that the duct tape was holding the jaw to the rest of the skull because when you decompose, your jaw is not connected because everything is skin and tissue or whatever. So the duct tape was holding it together. There's alternate testimony that hair and something else, not the duct tape, was holding the jaw in place. So interesting discrepancy there. And again, it's a matter of expert opinion. So if the state is saying, hey, duct tape suffocated or duct tape was involved in the death somehow, and there's an expert saying actually it was just over her mouth or on her face, but the jaw stayed in place because of some alternate reason, that's another hole in the state's theory. Um, I do think it's interesting, however, that there was testimony that the duct tape found over her mouth and nose was consistent with duct tape located in the Casey Anthony house. So even though we
Okay.
can't say definitively it's the same duct tape, it was consistent with the brand of duct tape that the Anthonys had.
So help me analyze this. I know you've been exposed to way more evil in human society than I have, but help me analyze what's going through the prosecutor's mind here. Because as a juror, as someone who's just trying to process this case, I don't buy this. I don't buy that a mother would kill her daughter via duct tape. I mean, I don't want to, put on a chart where the more ways that are, gruesome to kill someone, right? It's not some kind of like hierarchy,
Yeah.
but to suffocate my daughter with duct tape so that she slowly dies because she can't breathe,
Yeah, I don't know.
that's
I think
vicious.
it is vicious, and I don't think that I th I see what you're saying. I don't know. In hindsight, I see the issue. I don't know that I would have said she was because
I mean, this is a mafia
I
hit, right? This is what you
yeah.
do to a
Instead of being
person.
right, instead of being like, okay, she drugged her and then duct taped her so she wouldn't make noise, but if she was drugged, she's not making noise anyway. I don't know.
I
I don't
mean, I
know.
just wonder if the prosecution really thought through their theory here and how that would be perceived. And maybe they just were in a laboratory thinking, we got point A, point B, this all kind of makes sense. And so let's run with it without thinking, but would a jury buy the fact that some mother would do
Yeah.
this to their daughter? Now, in the Alex Murdaugh murder trial, I had the same problem with it. I thought, what dad with his son that he loved, even that day was loving on his son, would shoot his son twice at point blank range. I didn't buy that.
We're gonna have to unpack that case really soon because I genuinely think that there was plenty of reasonable doubt in that case, and I
Right.
don't know that I would have convicted
The
him.
only reason why, in my mind, it made sense at the end of the day, and I'm not saying my theory's right, but the only thing in my mind how it made sense was, oh, he's taking so many opioids that he was so drugged up he wasn't in his right mind. And okay, well, if he's not in his right mind, then I got that. Are they? Is that same issue here or same phenomenon here? They're saying she wasn't in her right mind, and that's why she did this. Was there any allegation that she was hooked up on drugs when Casey was doing this?
You
That might
know,
explain why she did it.
that's a really excellent point. I don't know that there was any evidence that showed, other than she was partying all the time, that instead of it being she was doing it intentionally to, but again, then it goes back to it was an accident because if she, well, maybe not. If she was in
I like the accident theory. I think the prosecution should have went with the accident
I think so
theory.
too. I think so too. And unfortunately, I think in a case like this, when it's trial by media ahead of time and it's a sensational crime, you could easily be influenced by that media attention
Yeah.
to charge what you believe. Again, we talked about this. Their prosecutors, at least the elected official, like the head or the district attorney or whatever you have in that jurisdiction, is a lot of times elected. And if you have this case sensationalized and the facts are horrible and you're like, yeah, but we're only going to pursue manslaughter, that's not sexy. No one,
Right.
no, people want her to pay for what she did.
And do you
I
know what
get it.
also makes sense
They
now
should.
to me? That if the defense's theory was that they wanted to make it look like murder, they're trying to cover up this accident, they did not want to be found guilty of neglect, which that also makes some sense to me. Well, that explains the duct tape because that makes it look like it was murder as compared to how you're going to murder your child whom you love. To me, it's just the defense's theory is actually making more sense than
Yeah, no,
the
I don't
prosecution's
disagree.
theory.
The theories, I don't disagree. And you want to know what else? Her behavior had, okay, so say she was involved somehow in an accidental death, whether that be drugs or like drugging Kaylee so she could go party or in the pool even if we entertain that. Um, and then she's disposing of her body to make it look like a crime so she doesn't get in any type of trouble. Her behavior, her party behavior could be influenced by the trauma, like,
Yes.
okay, I know my little girl's dead and now I'm just going to be drunk and high every day or drunk for the rest of forever until this comes out.
Yeah,
Yeah, I
she
mean,
goes
I
off the deep
that
end.
would be another excellent theory that the defense could have pointed to, and instead of the sex abuse, and instead of that just being like she knew her daughter was dead and she was trying to cope.
Because in my mind, that is a much easier sell than some, even 22 years of age, killing their daughter so they can go party. To me,
Yeah.
that unless this person is diabolically just insane at a level that,
Evil.
right, that I can't even describe, I'm not
Yeah.
buying that. I mean, the worst person I know wouldn't do that. But
Yeah.
all right, let's jump in here now to a couple other witnesses. You got Dr. Werner Spitz critiqued the autopsy as a shoddy, saying duct tape was placed post decomposition. Again, this just kind of highlights that that's the defense's job to poke holes in the prosecution's theory of the case. Cindy claimed that she made the chloroform searches herself, which again, I'm not sure I buy that because she was at work while
Yeah.
those searches were done. And so the FBI examiner found no sticker on the duct tape. Crystal Holloway. Oh, this is an interesting one. Crystal Holloway was the, I'm going to say alleged because it has not been proven, but the alleged mistress of George. George was allegedly having this affair with this lady. She comes forward to say that George called Kaylee's death an accident that snowballed. Now, George has denied the affair, you know, but that she was put under oath. She was called to testify. She testified about this affair and said that George described Kaylee's death as being an accident that snowballed. Any thoughts?
That's an interesting one. I don't know how the affair is relevant other than it goes to credibility. As far as how she knows George, and if what she's saying is true, then maybe he really did say something of that nature to her because he trusted her. Um,
So she said that he was sitting on my couch and I was sitting on the floor. He said it was an accident that snowballed out of control. I was in shock. And by the time I looked up, his eyes were filled with tears. And I did not ask him anything further. So now, obviously, doing cross examination because there are two sides to every story. The prosecutor, Jeff Ashton, got out that she was offered $4,000 by the National Enquirer for that story. And if it's an affair, it makes it more sensational. And so that helped to sell that story. So, again, there are two sides to everything, at least
right.
allegedly.
And why is this the first time that anyone's hearing about this? You know what I mean? Like, why? I don't know.
Right. It's um do
Like,
you
why didn't you call the police?
right, right. Yeah, back then you think you would have come forward a little bit sooner. Do you think the judge could
Right. That's
have
what I mean.
right? All right. So then Cindy Anthony was called again. This is June 23rd. Cindy Anthony was called for the third time, and this was actually she was called by the defense. Before we get there, then, before we get into the defense's case, which actually I already got into the defense's case, but let's just pause here for a moment because I can move these things around. But how do you think the prosecution did? So the prosecution ended their case, and with their forensic testimony, is that ending it on the high point? And how do you think the prosecution did?
I think overall, I mean, they gave everything they had, which is all a prosecutor can do. So my job is not to win, even though we all like winning. You know, I don't go to trial on the assumption I'm going to lose, right? My job is to deliver all of the evidence that I have in my file or in the case, deliver it to the jury the way that I believe it needs to be done for justice to be done. And what the jury then does in making a decision is what the jury does. That's my job isn't to win or lose. My job is to present my case. And so I think in this case, they did just that. I mean, I'm not now that we've broke down the theory and the defense's alternate theory, I'm not really sold on the state's theory of the case. But as far as presentation, 9 out of 10. They've gone chronologically. They've done what makes sense. They've got they call their witnesses in the order that's easy to digest. Again, chronologically. They've got their experts. They've got the forensics. I think the forensics are a high point because, again, the circumstantial evidence of the laundry basket. There's two. They're sold in a pair. Only one was found in the Anthony home. The sister laundry basket was found with Kaylee's body. Kaylee's body was found with the Winnie the Pooh blanket that matched her nursery from the Anthony home. The duct tape, consistent with duct tape that was found in the Anthony home. The odor of decomp, the science, even though some say it's junk science or underdeveloped science, of the decomp in the trunk. Um, all of these things are what the case is based on. And the fact that they got all of that evidence in and they did it in a way that followed the rules of evidence, they did it in a way that was easy to digest for a bunch of 12 lay people, 13 lay people, how many ever people were there, depending on alternates, is all they can do. And so while they get 1 point off, you know, for their theory not being as good as I wish it was, all things considered, they presented their case. They presented what they had. I will take this time again to remind everybody that direct and circumstantial evidence are two different types of evidence, but juries can consider both and can convict on just circumstantial or just direct. In this case, if you look at it, totality of the facts, totality of the evidence, it is circumstantial because no one has any direct evidence that Casey did it, saw them do it, her do it, whatever. We can look at the bigger picture and say what makes sense. Put the pieces together. I'm asking you to hold her accountable beyond a reasonable doubt. And I think they did the best they could with the information they had.
All right. Well, now let's get to the big question everyone wants to know in murder trials. Should the defendant testify? So
I don't
if you're
care if it's hang on. Go ahead.
if you're looking at the case and you're keeping score, I mean, the prosecution has to prove their case. If you think you've won the case and the prosecution is not proving their case, you're not going to call your witness to the stand. And
You should
especially,
never call your witness to the stand
I mean,
ever.
your client to the stand.
Yeah,
Um,
that's what I meant.
in here, especially when she's done as crazy the things that she has done. I mean, she's done some things that are just totally inexplicable. It's not going to go well if she has to explain herself. So, would
Yeah.
you call the defendant to the stand?
Absolutely not. It's obviously their right. So the defendant gets the choice to testify, and their silence can't be used against them because we have the Constitution, that fancy piece of paper. But the silence can't be used against them. And as an attorney, as a defense attorney, I am telling my client, I am advising my client every day of the week to keep their mouth shut, to sit here and stay quiet because we don't have to say a damn thing.
So during the OJ case, at this point in time in the proceedings, the defense lawyers were like saying, "We knew we had this one. I mean, it was already in the bag." In fact, their biggest concern was that if the case went on too much longer, they might lose their jurors and a mistrial would get declared because they were only down to, I think, one alternate juror left. So they wanted to wrap the case up because they knew they had it in the bag because of all the mistakes that the prosecution made. So here, is that what the defense is thinking? Or do they know they have this in the bag, or are they thinking this is up in the air? It can go either way. How do you think the defense is thinking that they have done, or how they think the case is going at this
Sure.
point?
No shot does Jose Baez actually believe that putting Casey on the stand is even like on the playing field or like
Okay.
in the no way.
No,
No way.
okay.
I think he thinks that there's a risk. I think that he thinks he's doing a great job, and he did, clearly. But I don't think that in any world did he think there wasn't any chance, or sorry, I don't think in any world did he think it was possible, like 100% certain they were going to acquit her, so it wouldn't matter if she took the stand or not. I think in his head, he's saying, hey, I think we're doing all right, but you are absolutely not going to get on the stand because you're going to be under oath and your credibility is going to be shot because you aren't going to come off as genuine. Your behavior is bizarre. You can't explain it. All
Okay.
the things.
So there's zero shot that any lawyer with a bar card is going to allow their client to take the stand in this case.
It's the client's right, but there's no shot they don't advise their client
Strongly.
probably with air guns. You will not do this.
Yes. Right. I agree
know.
with that one. All right. Hey, you know what? It's been a great episode so far. We went a little bit long, but let's break here. In our next episode,
Sure.
we are going to announce the verdict. Now, you know what the verdict is, but here's where we're going to go with our next episode. Why the jurors ruled the way that they did. And so you will not want to miss our next episode.
Yeah, come back.
All right.
Thank you.
See you next time.